Today's topic is what is an unlawful detainer. An unlawful detainer action is a California statutory procedure in which the court makes a determination as to who has the right to the property in a dispute between the landlord and a tenant. A landlord will bring an unlawful detainer action to ask the court to permit the landlord to take back the property from the tenant. But why can't the landlord just take the property back after the lease is up? This is because under California law, generally no self-help is the rule. This means that the landlord cannot simply evict a tenant on his or her own. It doesn't matter whether the tenant is breaching the lease or rental agreement or behind on rent. Nor can a California landlord unilaterally decide to lock the tenant out, dispose of the tenant's possessions, or cut off utilities without a court order. Only the sheriff can evict a tenant, and with few exceptions, the sheriff will only evict the landlord tenant after the landlord has served the tenant with a notice, such as a 3, 30, 60, or 90-day notice, wait for the notice to expire, and then files an unlawful detainer action once the notice expires. Again, the landlord has to serve the tenant with a notice, wait for the notice to expire, and then if the notice expires and the tenant still has not complied, the landlord has to file an unlawful detainer action, and the tenant, who still hasn't honored the demand in the notice, must lose in the unlawful detainer proceeding, such as a favorable judgment awarded to the landlord by the court. An unlawful detainer is a statutory procedure. If you want the actual California Code of Civil Procedure, it's section 1161 to 1179, and that is what governs unlawful detainers under California law. Again, an unlawful detainer permits a landlord or agent to regain possession of the landlord's premises occupied by the tenant. And an unlawful detainer procedure can only occur after the tenant's right to possession has been lawfully terminated. In addition to repossession of the premises, a landlord can recover rent that has been unpaid for up to 1 year if the unlawful detainer began as a 3-day notice to pay rent or quit. The landlord can also recover lost rental value as damages beginning on the date the tenant's unlawful detainer began. In addition to California Code of Civil Procedure 1174, landlords can recover statutory damages of up to $600. So let me rephrase that. California Code of Civil Procedure 1174 permits a landlord to recover statutory damages of up to $600. A landlord can recover interest, court costs, and attorney fees if provided for in the lease agreement. But an unlawful detainer cannot resolve disputes over security deposits. An unlawful detainer proceeding cannot be used by a defendant to recover money from the plaintiff. Instead, the defendant will have to file a separate action against the plaintiff in another court proceeding. So the tenant cannot file a cross-complaint in an unlawful detainer proceeding. It has to be a separate proceeding. An unlawful detainer proceeding also cannot be used by the landlord to recover lost profits by the landlord for rent that was lost because it took the sheriff a week to finally evict the tenant. If the landlord wants to recoup lost profits for the duration while the sheriff postponed the actual eviction, then the landlord will have to file a separate action to get back the rent lost during that period. When is an unlawful detainer available? An unlawful detainer is available at the expiration of a lease. So when a tenant remains in a leased premises after the lease ends, the landlord can file an unlawful detainer action to remove the tenant who stays past the expiration of the lease. But make sure you read over your lease to check whether your lease requires one party to provide written notice of non-renewal prior to the expiration of the lease. And also, as a landlord, you need to be careful of accidentally creating a holdover tenancy. A common mistake made by landlords is when a lease ends and the landlord accepts rent from the tenant. Even if done with good faith by a landlord that accepts just a partial payment by a tenant that promises to leave, this can create an entirely new month-to-month tenancy that must be terminated by a 60-day notice if the residential tenant has been in possession for 1 year or longer. Although some exceptions do exist that allow landlords to accept rent past the lease expiration or to shorten the 60-day notice period if the property is going to be sold, these exceptions are rare and you should not necessarily rely on them to apply to your situation. 2. If the landlord terminates a month-to-month tenancy. Similar to expiration of lease mentioned just before, if the landlord terminates a month-to-month tenancy and the tenant refuses to vacate by holding over, then the landlord can initiate an unlawful detainer proceeding against the tenant. And also, same as before, if the residential tenancy has been in effect for longer than 1 year, the landlord must provide a 60-day notice to terminate the tenancy. If the tenant breaches the lease or fails to vacate by the agreed upon deadline, or when a tenant is unable or unwilling to vacate a premises by the agreed upon date, the landlord may institute an unlawful detainer proceeding. Now, there is an exception for domestic violence, sexual assault, stalking, human trafficking, elder abuse, or adult dependent abuse. And if a tenant is a victim of any of these, the tenant can terminate a tenancy by providing the landlord only 14 days written notice, and then providing the landlord a copy of the police report or protective order or restraining order within 180 days of the order going into effect. After the 14-day period, the tenant is legally discharged from the lease, unless the property is rented to another tenant before then. That would be even more in the tenant's favor. This does not relieve any other tenants on the lease from their obligation to continue paying. So just to clarify and revisit, a tenant can get out of the lease, no matter when it started, no matter when it ends, within 14 days if they are a victim of domestic violence, sexual assault, stalking, human trafficking, elder abuse, or adult dependent abuse. And they have to follow the steps outlined earlier, and it doesn't mean the other members of that household, if they're on the lease, are discharged as well. I don't need to talk about children because they wouldn't legally be bound by a contract, but if there's other adults that are co-tenants and they are not also victims of the aforementioned types of abuse, then they are still subject to the full rental payment. And there's another early breach option for the tenant. If the tenant wishing to utilize this 14-day early breach provision does not actually have a police or protective order, then under Civil Code 1946.7, the tenant can send the landlord a written termination notice and attach a letter from a qualified third party that the tenant or household member is seeking assistance for physical or mental injuries or abuse resulting from being a victim of the aforementioned acts. Termination of employment-based tenancy. When the tenancy is tied to the tenant's employment with the landlord and the employment has ended, then the landlord can institute an unlawful detainer action to remove the former employee. If you, the landlord, are providing tenancy to an employee pursuant to a continued employment, then you should have a clause in your employment agreement that defines the specific time period in which an employee shall vacate the premises following termination of the employment. Waste or nuisance by tenant. That's another reason for the landlord to bring forth an unlawful detainer proceeding. And lastly, sale or foreclosure of property. So if you purchase a property after a sale or foreclosure and the previous owner or tenant remains, the purchaser can implement an unlawful detainer proceeding after only 3 days written notice. However, there is a new state law under section 1161 Bravo and subsection Alpha that applies until December 31st, 2019, which requires a purchaser in a foreclosure sale who wishes to evict tenants in an existing residential month-to-month lease to provide the tenants with 90 days notice. And remember, all notices must always be in writing. Verbal notices are not worth the paper they're written on, as they say. So that concludes today's presentation. Thank you for watching. Please let me know if you have any questions or any suggestions on how I can improve. This is one of the first in a planned series I intend to put out. My name is Nick Cohenmeyer. I'm a California landlord tenant attorney. And yeah, let me know if I can try to help you.